It's a movie, but I can't tell you which one.
Okay, it is 6 o'clock, and I thank you all for being here tonight. This is a continuation of a public hearing, the Zoning Board of Appeals over the applicants of Truck Orient Express, who are appealing a decision by the zoning enforcement officer in response to an enforcement request that was made on 7/15/23. I'd like to mention that we've had a couple of late developments. Joe has started the recording, but Joe is going to take care of his wife tonight, who had some work done on her knee today. And also that I got notice from Brian Duvall late this afternoon that he has a knee injury and is having difficulty walking. I sent him a note asking him to call me. I just tried calling his cell phone, and I don't know whether he will be here by phone, but my phone is ready if he does call. Aside from that, we have the board here, and I think we're ready to commence. Thank you, Amy, for sending out the materials. Thank you, Truck, for doing your analysis. And also, I want to thank Jack for making arrangements to work with our consultant concerning this. Anybody on the board have anything to say before we get started? Okay. Jack, you want to start?
Well, my suggestion is maybe to get a handle on all the exhibits first, because we received some documents and information from Mitch, and then we received some information from our so-called the board's expert.
Okay, so we're going to call Mitch's second packet Exhibit 2. Okay.
And can we maybe define that by including what I saw was a video and, correct me if I'm wrong, Mitch, an Excel sheet and then the raw data, or how do you want to call it?
Was there a sound clip?
Soundings?
It was an Excel document with 3, maybe 4 spreadsheets, and then tabs, and then over.
Tabs?
Yeah.
Yeah,
So
okay.
within Excel, there's tabs, so we analyzed the data various ways.
Let's just describe it.
And then,
So
one is the raw data that we took from the raw file, put it into Excel. The other tab, we sorted it by just anything excess of 65. And then we did a chart. Just last meeting, someone said, is there a chart that I can see? So.
Okay, so we make that Exhibit B?
No, I'm sorry. I'm going to renumber that. That's going to be Exhibit 3. Exhibit 2 would be Amy's. And Amy, could you explain what you sent us the raw data? What are the parts in there?
You mean the one that was sent to everybody?
Yeah.
Yeah. So you sent it to Brian. Brian sent it to us.
I just sent what we always send typically, which is the entire recording that was made on July 15th, the log text, and also the audio file.
Okay.
And what are we making Exhibit 1, the appeal?
Yes.
Okay.
As laid out, is the application for the hearing, the continuation sheet, and exhibits A through D. Okay, so now we're up to Exhibit 4, which would be Herb's.
Yeah,
No, sorry. Exhibit 3, we also submitted audio file.
that's what I have
And a
that.
Word, and a Word document.
It's all
which-
part of Exhibit
It's all
3.
part of
Right.
Exhibit 3, okay,
Right, that's what I was attempting to describe.
okay.
That includes that.
Yeah. Okay?
Okay, so
So then
now
4?
4 will be Herb's, which I sent out to everybody.
And this
The
is
correspondence back and forth.
This is from Herb Singleton of, I think it's acoustic design. I'm sorry, Cross Spectrum Acoustics.
Can I take a look at the actual appeal itself, your Exhibit 1? I don't have it handy and I want to look at it.
Also, Doctor, could you clarify, since you sent a couple of emails?
I
Is
sent
this
4
the
because I couldn't.
9:59 a.m.
Or 3, I'm sorry. That's the original one.
Yeah, thanks.
Would you repeat your question?
Yeah, Herb sent a couple, there was a little back and forth.
Yes.
We're talking about the 9:59 a.m.
Yeah.
Okay.
Yeah, I sent the correspondence that went between Jack and Herb, as well as, I tried to include if there were any attachments.
Yeah, that was very helpful. I just wanted to make sure we had the right. It's Exhibit 4, the one where
But we'll combine that together.
he has an annotated list of
Yeah,
law.
I didn't have a chance to print them.
Jack I didn't print it out.
Okay.
Jack can tell you what specifically.
Well, we'll just label it Exhibit 4, and with the, Mitch just referred to, I think, among other things, the cover email from Mr. Singleton, which he describes as a spreadsheet, and what he did, and how what type of, I'll call it an examination that they performed. And so it's described in his email to me dated Monday, November 13th at 9:59 a.m., followed by their, looks like, I'll call it raw data. So that's Exhibit 4.
Was that the only thing he sent you?
There
There were also some, wasn't there a later email?
The only, let's see,
There's another one that has some substance in it.
okay.
Uh, Actually, there's a couple more.
I thought I sent 3.
So, yeah, we have another one at 3:21 PM yesterday, Monday, November 13th. That, why don't we make this a separate exhibit? Does everybody have that one?
What time?
3:21 PM.
Yeah, we have that.
Okay,
And also, there's another one, 356, I think.
okay. You have that one.
Yeah, one of them, they seem to repeat it. There seemed to be a repetition in them, wasn't there?
Thank you for that,
Same email sent
that
twice.
comment.
What, no, one email got sent twice, didn't it?
No, this is the only one I got at 3:21.
Oh, I thought there were 2 emails that came like right after each other that were,
Well,
seemed pretty darn close.
there could be.
I tried to make sure that I got everything that I received. to you guys.
Jack, you have 356.
Well, first of all, let's make the 3:21 PM email from Herb Singleton the next exhibit.
So that'd be Exhibit 5.
5. And then, let me just see here, that later one. Do you have a copy?
959.
Oh, I thought I,
There's one at 356.
959 that's Exhibit 4.
right, that's 4. So, Dutch, do you have the one at 356?
Yeah.
May I see that?
Can request all, right, this is what I can request on, then he says. July 29th, May 12th, we did that.
Yeah, that's already done. That was included in the last one. Yeah, so it's just about this.
Right, so that's my point.
Okay.
That's,
Okay.
I'm with you.
Yeah, okay, thanks. Thank you.
Make a copy of mine if you want, nobody else has it.
Yeah, I don't think I brought a hard copy. I just want to make sure that we were talking, okay. Yes. So, do you have a hard copy of this or no? I don't want to take your copy. Can we, is there a copy machine around the corner? Is it operable?
By somebody who knows how.
It should be.
Excuse me for a minute.
Can I see that?
Oh, yeah, he's good.
Did you want to print that? That's the last one.
I got that, yep. 56. I have that here.
Okay.
Thank you.
Congratulations, Counselor.
Thank you. Okay, so this is a series of emails, the front page of which is dated November 13th at 6:28 PM. But again, it's a thread of emails between myself and Herb Singleton. So make that 5,
Yes.
okay?
I thought 5 was the 321. Does that include both?
Okay, you're right, number 6. Okay. There you go, Dutch.
Okay. We're at the stage where we decided at the last meeting that we were going to look at the raw data as a board, even though we are not qualified sound engineers. And I think our discussion should begin with a brief summary of what we discovered by looking at the raw data. Do we want Chuck to start?
Well, I think that, just to keep everything in focus, that at least I'm cognizant that this appeal, may I borrow this just for a minute, Robin? This appeal concerns the board's interpretation of some of the enforcement of its enforcement powers under condition 6 of the special permit dated December 8, 2022. And specifically the manner in which the zoning enforcement officer is to go about possible enforcement, evaluation of a complaint to which asks for enforcement of the special permit. That's how I understand the appeal. And Mitch, if you feel differently, I invite your comments. However, it's my opinion that in addition to, so we're here, one of our tasks is to provide our input as to interpreting the enforcement provisions of condition 6 of the special permit. However, I believe that we additionally have the power ourselves to evaluate the same or similar data for what the building inspector would have reviewed, and make our own decision about whether or not there was the conditions, the soundings on July 15th were violative of the special permit. So that's the backdrop. I don't believe that we are required to, because it's technically outside of the appeal, but that we can. And again, I'm only speaking as a singular board member here, that we've had a number of appeals. We've had a number of, I should say the town has had a number of complaints. And I, for one, am concerned about this just keep going without an end. And I think that both the town and the participants, deserve some sort of direction from the board, to the extent that we're able to give it, about how this thing is going to work in the future. We kind of know how it's worked in the past, and my own opinion is that it has worked very well for the way it's written, and it's made it difficult for us to interpret it. So I felt that it was important to get some input from the professional that we've used in the past about the allegation that there was a violation on July 15th, and to try ourselves to go through the same or similar analysis for what the building inspector would do. I think we agreed that the public comment would, I don't know if I want to say stay open or reopen. So, yeah, I would think that we should hear from the applicants in whatever order you decide first, about what, including what they've seen for what our expert has provided us with, together with some of the materials that Truck has supplied us with. Because keeping in mind that she didn't have the data until we received it after the last meeting. So,
Let's start with truck then. Unless you have an opening statement.
I do.
Okay, then can you come up
Yeah.
here just so that you're,
Sure. Thank you so much.
Keeping in mind that we're the
Yes, but I've not been able to speak for any of these hearings, so I really appreciate, it's 2 minutes. This ZBA hearing is an appeal of the zoning enforcement officer, Brian Duval's decision to only ask for documentation of a certain time period rather than the entire log recorded during the July 15th, 2023 event at the Foundry. The special permit we received issued a year ago in perpetuity required us to purchase equipment that records every event that uses amplification, to take my glasses off, at our venue. In addition, we are required to provide Brian Duval, zoning enforcement officer, with the documentation from the equipment within 48 hours of any complaints from truck when. We have complied every time we've received notification that there's been a complaint and submitted all of our evidence of compliance. When Truck complained about our July 15th event, Brian Duval only asked for a limited amount of the documentation, which we gave him immediately. For all other past complaints, we have provided the entire log and audio files and have no issues in doing that in the future. When Brian Duval asked that we submit the entire log files and audio to the ZBA for July 15th event after the last meeting, we did so immediately, right? We did so immediately, because we have it at our fingertips. This appeal tonight and 2 weeks ago is only to decide whether or not Brian's enforcement must require the entire recorded log from each event for which truck files a complaint. There were many emails sent back and forth for the last 24 hours, entirely irrelevant to this meeting. A cell phone video taken on the west side of our building on our property during an event is not relevant. A recording submitted from equipment that is not documented from a location that is not documented is not relevant. The Foundry has complied and documented evidence of compliance with professional, calibrated, certified sound equipment. There has been no evidence submitted of equal quality from the complainant. This will undoubtedly be considered in the land court case where Truck Union is appealing to our special permit, and we and the Planning Board of West Stockbridge are the defendants. Everybody knows that, right? We all understand that that's happening. But again, none of this is relevant to the appeal at this meeting. The legal fees that accompany the extension of these hearings are extraordinarily costly by the hour. The ZBA members' time, we respect that is valuable, and all of our time is valuable, all of our time. The town is spending taxpayer dollars, just saying, and I respectfully ask you to please make a decision regarding this appeal so that we can just move forward. We want this to work out, and we have done everything that the town has asked us to do, including moving the microphone after it was decided by Brian that he didn't have us put it in the correct place, which just as an addendum hasn't changed at all any of the decibel levels that seem to be pretty much standard across the board in terms of everything that we submitted you before for previous hearings in terms of the ambient sound levels. The levels kind of are the same for when we have events and when we don't have the events. Actually, they are the same. So I appreciate you listening before all of the evidence that was submitted at the last minute is reviewed. Thank you.
okay. Richie, are you or is it going to be Truck?
I'll speak briefly, and then Truck may want to make a few points. So let me start by saying that we appealed because Brian had not requested the data that he needed to, nor did Amy supply it voluntarily. Had we had the data, we would have looked ourselves, as we often have, and might have even decided to not appeal the sound levels. So in terms of going forward, a point that Jack made, we think it's very important going forward that it be clear that Brian has to do exactly what the special permit says. Request the data for the whole performance. Amy says they have no problem doing it, but I think it's important that it be embodied in a board order in case somebody changes their mind down the road, number one. Number two, we looked at what Mr. Singleton did, your engineer. Oh, incidentally, Tripp looked at the data, she counted it up, she sorted out, it's possible to sort the spreadsheet by the DBC level, and she came up with a number of violations which were greater than the allowable amount. So without question, at least on the face of it, it needs more inquiry. Brian sent you an email after he said he couldn't be here, saying that he looked at it, he didn't find enough points. It's impossible to know how he counted or what he did, but with respect, he's simply wrong, simply wrong. Now, a couple points about Mr. Singleton's thing. First of all, he looked at a short period, which he selected sort of more or less arbitrarily. And as I understand it, he put it to you, I'm going to show you what I can do by sampling like a short period. Here's what I can do. If you want me to do it for the whole thing, I will. I think the subtext being that it would cost a lot more money. So I don't know what you decided about that or whether he eventually did that. You know, the period that he looked at was not a period that was necessarily the worst sound. So I don't know what to make of his data. We come up again with the idea that there's mixed source, there's wind, there's the other. I think Brian should be making these judgments in the first instance, but if the board chooses to do it, great. But the most important thing for us is making it clear that they've got to submit the whole log. As far as saving everybody time, money, and trouble, had we seen the whole log, the last hearing might have been unnecessary. This hearing might have been unnecessary. Legal fees for Bill and myself would have been unnecessary, and the expenditure of your time might have been unnecessary. Because whatever is said by the foundry and its representatives, Tripp does not appeal every time there's a problem. She appeals if she thinks there's a serious problem. For instance, last Saturday, I believe it was Saturday, there was an inappropriate parker that she had to warn off, and it didn't appear that there was anybody monitoring the parking, which is a violation of the conditions. We're letting that go. We've let a lot of things go. But we need to know that we can resort to the law when we have to, and we need to know that Brian can't simply reinterpret a law that he doesn't like, even though he advocated it at the beginning. We need to know that Tripp is entitled to the same protection of the laws as every resident of West Stockbridge. And that's really why we're here tonight.
No, I said that, I just said that. Also, he didn't want it, he told me not to.
So just to make sure it's clear, when we felt there was a violation on July 15th and we requested data, what was given was not what was received in the past. It was in PDF form. I explained that in our last hearing. And that's why the frustration that we don't have access to the data that we believe we should have per the special conditions. And again, another frustration was that we had to stop our service to go out and measure and get a sense of the time frame to see if there was a violation, to even ask, and we had to do it within an hour period. So that's not how I read the conditions of the special permit. If there's a perceived violation, we have the right to ask for data and receive it in the manner that we have been receiving it the other 8 times that we've asked for data, to analyze it, to not waste everyone's time. And
Chuck, if we agree with you on that, can you give us the linguistics about can you describe what the previous data was that you were given?
yeah, Amy sends the raw data in a text form, and what we do is just like what Herb did, is he took it, he cut and he pasted it into Excel.
So raw data in a text form?
Into an Excel, yeah, into an Excel spreadsheet. That's how his report had the columns that said primary, music, secondary, insects, birds,
Yeah.
traffic, and then he had a column for X, which was predominantly.
Is that the form that you had been receiving previously?
No, it's raw data in a .txt
Yeah,
format.
but are you asking for the building inspector to necessarily put it in an Excel format? Okay.
The way Amy has given it to him per our request has been fine.
Okay,
But to receive it from him in PDF, which does not allow us to go through, I think it was 35 pages for 1 hour's worth of data, and analyze it, is not acceptable
It
to
wasn't
us.
for the whole period.
Yeah, and it wasn't for the whole period, it was
Right.
just for an hour. So, so that's the first point. Another point to make is there's been communications when we do ask for data because we perceive there is a violation, to come back and say, I'm not gonna deal with these baseless claims, I feel is unacceptable. They're not baseless. We have to spend money, just like Amy does, to protect ourselves. It's not baseless. Brian said he found nothing, it was 90 seconds of excessive. So that leaves another 30 seconds. Fine. How did he analyze it? Just like Mitch said, how did he analyze it? To come up with 90 seconds, not 91, 92, maybe, whatever. But somehow it's shy of the 2 minutes, right?
What did you come up with?
We don't complain all the time, let's just make that clear. There's been, like 40-something events this year. It's only the ones that you can actually hear when you hear it yourself, whether it's, you believe it's past the 65 or not, but you can hear it. And another thing that has to be addressed is, and Herb actually reiterated this to you all in his report, in his recent email correspondence. Sea levels travel differently. Okay, we're not here to debate the way the planning board wrote that, but sea levels travel differently. And the microphone placement of July 15th was not placed in the proper area. So what exactly is being captured to make sure that we're protected? Now, has anyone gone down and measured exactly where the mic has been moved? And if that's compliant, and if that's correct? I don't know. But since that movement, there has not been performances or programming that has hurt, that has disturbed us.
Since the mic was moved from the one location to, can I call it the proper location? Or a different location, okay.
closer to where it should be, but has it been validated? Has it been checked to make sure that it conforms with the planning board's intention of where it needs to be?
Do you have a suggestion on how that could be determined?
Yeah, with the tape measure. If Brian were here, he could tell us if he's done it, which
If
he
he's
should
done
have.
it.
Okay.
So there's things that the planning board has set out that are not being followed through with in terms of enforcement to make sure that we are comfortable, that we are protected.
Can I just say, ask either Amy or her esteemed attorney here, I understand, it's been made clear, at least to me, that the Foundry opines that we shouldn't deviate or expand the appeal to anything other than what's contained within the appeal. My question is do you deny my opinion, do you disagree with my opinion that however we may, if we so choose, in this case, determine the merits of an allegation to determine a violation?
I do just.
Whether or not we should,
No.
whether or not we have the power.
No, I don't think you do. I think it would have to go back to Brian and then come back up to you. But I'm here to be a problem solver. You might find that hard to believe, but I really am, okay? Because what I heard the last time really struck me that Brian doesn't have the technical word processing skills to look at the data that comes in its raw form by manipulating an Excel spreadsheet. He just doesn't know how to take the text file, turn it into an Excel spreadsheet, and then sort it. We have never had a problem with providing the raw data that the computer generates. Not a problem. Brian, I believe in his effort to try to manage this workflow, I think somewhat reasonably said, hey, give me an hour time frame that I can look at, because I need to look at these things one by one and tick them off, and it's very burdensome. I do agree that there's a more technologically better way to do that, okay? And so Amy has never resisted providing the entire data log in its text file format. What I would suggest, whether you can do it as an order or whether as a strong suggestion, a procedure would be, if they want the text file, that Brian gets the text file. Brian then doesn't do anything with the text file except send it to Mitch and Truck. She then has an opportunity to convert it into Excel, sort it like she did, graph it if she wants, highlight the cells that are over, and count the cells that are over. So we will start out by knowing, just mathematically, because each cell is a second, right? Now you also have to know what the start time and the end time is, because the recording device starts before the event starts and continues after. So you're going to have to pick the start time and the end time. So Brian's going to have to know that. So I would propose we give him the log, highlighting the start cell and the end cell. There may be a half an hour that it's turned on before, there may be a half an hour that it's turned on after. Those sounds don't count.
How do you know when it is? Just because Amy knows when the event starts?
Yeah, and the event starts at 7:30, and she goes and gets sets up, and she turns on the recording device at 7 o'clock because she's got other things she needs to attend to. But the event starts at a particular time. It has a start time, and it has a stop time. And we would represent those as the start time. Now, then my next suggestion is we give Brian the Excel, the text file. He does nothing with it except give it to Truck. Truck then sorts it, counts it. If it's under 2 minutes, 102 minutes, 120 seconds?
120 seconds.
120 seconds, game over. There's no potential violation because it's under the 120 seconds. If it's over 120 seconds, then it's got to go back to Brian. Brian then needs the audio file, right? So we can do what we talked about last time, and what your expert is talking about, is making some rational connection between the sound that's over and whether it's generated by the Foundry. Because I think it's unfair to think that the special permit meant sound not generated by the Foundry counts. Think about this. In the last iteration of this, at worst, it was 24 seconds over. I've probably talked for about 4 minutes. Think about this. In a 3-hour event, we're talking about 24 seconds over the limit. We are cutting things with a razor here.
We didn't write the special.
I understand that, and we're all trying to struggle with it. And I will also tell you that it's on appeal, okay? And God willing, we come up with some rational, cooperative thing to go back to the board and say, do this, this will work. I told you last time, the offer that was on the table is no sound inside the house if we go record. But we're not gonna discuss the settlement, we're not gonna go there, okay? You need to help your zoning enforcement officer deal with what we have. And what we have is a horribly imperfect condition, okay? But the way to manage that is to not make him sit there, and I will tell you, the reason why the last one came in a PDF format is because when Amy was required to cut it down, she had to print it to a PDF file. She didn't have the ability to just dump the data out of the computer like she had before. She had to create the PDF file. So in fact, it generated more work for her to create a shorter log. So we have no problem with generating the entire log. What I hear the problem is Brian doesn't want to have to spend hours counting cell by cell whether it's over or not, and frankly, doesn't have probably the Excel computer skills to manipulate it in 2 seconds the way Truck clearly has. And so my suggestion is you enter an order or suggest, however you want to frame it, that says, Brian, here's what we want you to do. We want you, one, anytime Truck wants it, ask for the entire data file. Amy, if upon that request is asked, I think has no problem emailing it to Brian and me and to Mitch all at the same time. What difference does it make? Okay? But I would then put the burden on Truck, or whoever asked for it, to go do this manipulation and sort it by whether it's over or not. If mathematically it's not over, game over. If mathematically it is over, then it's got to go back to Brian, and he then has to produce the sound log, and then you have to go through the far more tedious task of trying to figure out whether or not these spikes are, car horns or music. And that's the part of this that I hope we can come to some accommodation in, going back to the planning board and saying, look, frankly, if we took the 2 minutes and made it 4 minutes, it may not matter whether it's a car horn or the music from the venue, because we've never had more than a few seconds over the 2 minutes in all of these events. The other thing we could do is we could move the mic inside, establish what the inside decibel...
Inside the foundry?
Inside the foundry. The decibel limits inside the foundry, obviously the limits would probably be higher.
That's a special permit.
Well-
That's a planning board.
Right, but I'm not asking you to do it, but what I'm saying is if you went back to the planning board and said, look, if you had to do this over, you put the mic in the foundry so there was no interference from other sounds, and then you took another measuring device and put it outside, right? And you raised the volume inside, and everybody stood outside and they said, okay, that's an acceptable level of volume outside, okay? Well, what was it inside? There's your cap. Because now we know what volume inside creates an annoyance outside. But we'd have to go back to the planning board to do that,
Other
okay?
than the comment about the inside-outside, what do you say, Mitch, about that suggestion?
I have to say that I will respond to that, but indulge me for 20 seconds here. With all the complaints and hammering about waste of time, what we're doing here, I don't understand why we're spending all this time dealing with planning board issues. Let's stick to the ZBA issues.
Okay.
All right.
Anything else?
Now, having,
Yeah, go ahead.
uh,
I just wanted to know if he was done, and then...
No, I mean, if you had any questions on my suggestion, I mean, I think that you guys are spending an enormous amount of time on something that really should not take any time. And we're here because I really think Brian Duval has felt overwhelmed by this in terms of how time-consuming this has become. And Amy wants to manage his time, my time, your time, everybody's time. And she's only done what she's been asked to do. And if she's asked to produce the text file to Brian, let him know when the event started and stopped, and you all don't put him in the position of having to try to count each one of those cells, by saying all he's got to do with it is turn it over to Truck. And then if the burden is on her to come back to him and show him the violation in the data, as opposed to having him go find it. If she shows him the violation in the data, then he can do some further inquiry. It cuts his time down to nothing. All he's got to do in the first instance is nothing, because the email just goes out. If it goes over 2 minutes, then he's got a little work to do.
Okay.
That's my position.
I want to remind everybody that early on, we suggested to the foundry that they supply us with the data directly on request. Do you remember that? And they absolutely refused, said it's got to go through Brian. Point one. Point two.
That was at the hearings in front of, not our board.
No, it was here.
Here,
It was here.
2 weeks ago.
It was here because Bill was here. And Bill was only here at this board. Bill was not at the planning board. Number one. Number two, Trip will be happy to review these, as she already has, but it's inappropriate to say that that's to relieve Brian of the burden. Under the special permit, it's Brian's job to do this. If he doesn't like the job, he can make some decisions about it. He has to do it. If Truk assists by supplying certain data, great. But let's say she's sick and she can't do it, or she's busy, it's still Brian's job to do it. So, do I like the idea, that we can look at it? Sure, that's what we've always done. But the idea that we'll do it to take the load off Brian? Absolutely not. If Brian doesn't have the skills, he can get somebody to assist him that does. Brian, probably without understanding what would involve, endorsed this plan at the planning board. The planning board put this load on Brian. It shouldn't just be transferred to Truk so that Brian has no responsibility. Now, I agree with Bill that when we get to the point of saying, yes, we're over the requisite time, and it's not correct that we've gone beyond the time a number of occasions, and Truk can speak to that if it's important. But, beyond that, there are some judgments involved, and a number of people, including your expert, have said it's impossible to make those judgments. That's one problem we have with the planning board's order. And he also pointed out that the ANSI standards, that some of us at least know what those are, these are nationally accepted engineering standards, say that you don't measure sound when the wind is over, 8 or 10 miles an hour, I don't remember the number. But there's judgments involved there. We may not disagree with his conclusions, but it's certainly not a clerical task. The first part, we're happy to help insofar as we have time, but it's still Brian's job. Brian is the zoning enforcement officer. And by the way, as far as cooperation, Brian saying to the foundry, put the mic here, which is like 40 feet away from where it's supposed to be, the foundry knows very well what the special permit says about where to put the mic. And as some of you have pointed out, there's no ambiguity when you read it. So the building inspector tells you to jump off a cliff, that's what you do. It's the permit holder who has the responsibility to do it right. So let's get everybody doing their job here. And it's not up to Amy to manage Brian's time and manage the process. It's a town job, and the town needs to do it right.
Well, I think as a practical matter, though, Brian may not, and as you pointed, I think you suggested, he probably doesn't have the skills to do it. The town's probably going to have to hire or bring in somebody else with that capability. And yeah, I understand, it's a town function, I get it. But it's just a practical observation, at least on my part.
Yeah, it is a practical observation. I agree with it, but by the same token, we're not talking about designing a rocket ship here.
Yeah.
I'm a dumb country lawyer, you know what I mean? And I can take a text file, import it to a spreadsheet, and sort it. Not as well as Truck can. It might take me a little longer, but there's plenty of kids out there, the same ones, the same 7-year-olds that we ask what to do if we need to set our watch. You know, there's a lot of kids out there that can do this in 10 minutes. And maybe that's what we need if we're getting into delegating jobs like this to the zoning enforcement officer, as a practical matter.
Okay, go.
Good ahead, sir.
Yeah, is this on?
Yeah.
Yeah, I think that the sorting task that we're talking about isn't as difficult as it sounds. The first time that we had to do this in the previous sessions, I did it the hard way, like you were describing, you know, I went through and I looked at each cell and tried to, and by doing one single additional sort on the data, you can put it in an order that makes it pretty easy to do. And I don't know if this is the time to do it, but I can explain how I sorted it down into, you know, a couple of minutes worth of sound to listen to. And it started with, like Trook did, you convert the text file into an Excel spreadsheet. Then I sorted it by the DBC column.
No.
You
gotta snap it to the grids.
Yeah,
It goes into Excel, it's a flat, each line is the flat, it doesn't hit it into the right columns. You gotta do another step to snap it into.
Yeah, but it did. The
Right,
way I
right,
did it,
but
I
I'm just saying-
accomplished that, yeah. But it's
But you
it's
can
not
do it.
brain surgery,
Right.
yeah. Once that's done, then you can resort the sheet
That's
a
right.
million different ways. And rather than sorting it from the bottom up, I sorted it from the top down with the largest DBC numbers at the top. And then I went down to the point where the transition from above 60 occurs, and I just dropped off everything else below that. So that what we had left was I'm not sure why you got a smaller number. I got 145 lines.
144, I came up.
Yeah, maybe it's because you subtracted the line numbers and didn't add one back.
I don't do 65, by the way. My threshold is 65.1.
Yeah, that's what I said, above 65,
Yeah.
same thing. Anything
Oh,
above
sorry, I
60,
didn't hear that.
greater than 65.
Yeah.
So, but in any case, so you end up with 145 seconds worth of information, but it's sort of randomized. It's in the sequence related to the DBC level that's associated with each line, which makes it awkward to follow. If you do one additional sort, according to the chronological timestamp of that, then you can put it into the order in which it occurred. And then if you want to listen to the audio and relate it to that, it's very easy to do because the audio has a chronometric stamp on it that corresponds. So you can just go, that's what I did. I printed it out because it was easy to do. I went to the first occurrence, which was at 06:30, and started the audio recording. And then you can see it. It was 66.3. I could listen to it, and I just made a note. It was a rumbling sound. Sounded like it might be a distant motorcycle, car, or a truck. And you can see by just looking at the numbers, they're in sequence. There's times 30, 31, 32, 34. So you get big blocks of it that you can go through in a pretty short period of time. Did that through the whole spreadsheet. Took me less than an hour to do the whole thing, and so it's not that difficult to do. And I think we could probably train Brian to do it without a lot of effort. He's a smart guy, and that would solve the problem, I think, just for what it's worth. I can tell you the results that I found.
What
later.
were your results,
Well, basically, again, this is only what the data is. I'm not refuting whether there was sound in your house or not, but this is what's in the recordings. The first block of time of about 5 seconds was vehicular. After that, there was another interval from 19 minutes and 7 seconds to 19 minutes and 13 seconds, it was absolutely a motorcycle going through town. You could hear it. It was a two-cylinder motorcycle. And then there was, following that, there was another, during that, that was so loud I could hear somebody standing on the street say, "Wow, that was loud." And that's captured in there. Then beginning again another interval from 1:29:16 to 1:29:19, it's clearly wind. There's no other sound. And it goes like that. There are longer intervals of 10 or 15 seconds at a time. There, you can hear, the band in the background sometimes, but honestly, the noise that pushes it over the edge that's really prominent is wind or people talking. It sounds like maybe it's intermission or something, and people are not standing, they must be right next to the microphone, but in the parking lot, it's people talking. And there were intervals where I could not hear the band at all, but the levels were in the 60s and 70s, and it was wind buffeting the microphone. You can do this yourself as well as I can. So to just look at the numbers and use them just as a gauge is just not, with, again, using the tools that are here and the data that's recorded, that's what you end up with. Most of what I heard was people talking, a couple of motorcycles, something that sounded like an airplane at one time. People with loud voices, somebody saying, "Shit, you know what?" Again, there's all that was 78.8 decibels. It's just, that's what it is. But you have to do this to know what those numbers mean before you can say those are violations caused by musical sound coming out of the building. So. No bearing on whether you hear it in your house or not. Those are just the facts as we have them in the data that we received and how it evolves. But I'd suggest doing that method yourself. Sort it one more time by timestamp, and then play the audio back starting, and you can match up seconds per second with the timestamps on the printout and the timestamps on the audio. And you can hear it for yourself. Anybody can do it. It's not difficult.
So with your analysis, was the number of times that music was the main source of sound more than 2 minutes?
No, definitely not. According to what was recorded here, and this, what you can hear very plainly when you listen to the recorded audio associated with these high level numbers that are above 65 dBc.
Does anybody on the board have?
Can we make that would you mind us making that an exhibit, Gunnar?
Handwritten scribbles.
It's okay with me.
That'll be exhibit 7.
Make copies of it.
Yeah.
So that's 7?
Yeah. All right.
I'm just gonna put a 7 in this thing?
Yeah.
Yeah. I have a copy of that sort here without my notes on it, if you want it.
I can have a copy of this made, if you so desire. Jim, do you have any questions for Claire?
This is the final sort, if either of you want to see it. It doesn't have my notes on it, commentary. But it's got the secondary sort that I did.
You have a.
You can do it. So this is the timer.
Yeah.
In sequence and the levels.
Okay, thank you.
The headings ended up at the bottom because of the sort.
Right.
Can we respond very briefly to that?
I want to have questions from the board first.
Oh, I just have,
Robin.
just one quick question. Well, I guess first to comment that I kind of agree that it is the job of the zoning enforcement officer, and the town needs to be able to somehow enable that, that when a complaint is made, that he has the ability to analyze the data, not just provide raw text files to whoever makes the complaint. If it's not truck in the future, then that's not really sustainable procedure, I don't think. It's just text. So I think if it's you or whoever, I think providing some type of training or template for Brian to use would be really helpful. My only question I did have though was last time you had, I appreciate the deep analysis, but last time you had mentioned you'd also spoken to, I think it's the microphone manufacturer about the issue with wind and how you mentioned like they make wind covers that could somehow kind of mitigate that. In the cases you were listening to, did it seem like wind was a I don't know, like so dominant that it muffled out what could be music in the
Yeah,
background?
when you hear it, you'll know it.
I need to speak to that, please.
Yeah, that's fine.
So I called the manufacturer
Yeah.
that I purchased the equipment from after we had the hearing that I was at. And there is a wind cover on it.
Okay.
It is an expensive wind cover. It is one of the best that you can have.
It's
So
the foam thing.
We already have a wind cover that makes it possible to sort out the wind as much as possible. Like you couldn't add a wind cover better than what we purchased
I think
from
that's
the
wrong.
manufacturer. And so I just wanted to just make sure that we understand that we're all on the same page, that the equipment we purchased is outside equipment. And so therefore, like, there's no way you can completely, if you cut out all of the sound from wind, you also cut out all of the sound from around. So you're not gonna hear music either. So it's the balance of the equipment, which is why it was so amazingly expensive and professional and calibrated, that was provided. We asked for weatherproof equipment, so we could put it out in the rain. There's a spike on it so birds don't come down and sit on it and muffle it or poop on it. There is a wind shield on it. So there's nothing else that we could get that would, if you got something more, it's gonna muffle out all the sound and you're not gonna hear anything coming from anything.
I think you're misinformed on that.
Well, you can call, I would be happy to give you the phone number.
I already have spoken with them, and I spoke with them
Oh,
last week
good,
again.
okay. I spoke with them too.
And you have the microphone with the protection package on it, which has the bird spike and so forth, and it's weatherproof, and it has the little small foam ball, which mitigates low-speed wind noise. But there are more elaborate wind baffles that can be used that.
It's true, but when they're used, they also mitigate the sound, the other sounds
That may be.
that are coming. And that is why they gave us what they gave us, because, sorry to interrupt you, but you have to understand my impatience at this point, is that because we've done all the research and spent tremendous amount of money and time trying to comply with this permit that we were given, and we agreed to comply, and we have. So if we went for, like, let's say you're shooting a movie, and you're outside and there's really high wind speeds, that isn't what we're doing here. We're trying to make sure that the sound coming from the venue isn't creating something that is over the decibels that we're allowed to create. So you have to be able to hear the sound coming from the venue. And if you muffle it so much, you're not gonna hear the sound coming from anything. And because the microphone's not like right up against the venue, it's at our property line. And so I did speak at length with them. So I don't know if they told you something different or if they know that they knew more of the details from what I explained to them, but it does have a muffle for the wind on it. I just wanted to be sure.
Yeah, I think I'm trying to address your question. When you do hear the noise, the wind noise, it's obvious.
Right.
You can, it sounds like, literally, it sounds just like that when you hear it. So it's not hard to misinterpret. So, and I don't think I don't think it's a big issue one way or the other unless it was continuous so much
Right.
that you couldn't hear the other sounds to make a decision. But when it's, the way it seems to manifest itself in that area is gusts, and you'll hear that sort of noise over top of the other sounds that are there. So I mean, you could get something elaborate, but I'm not sure that it's necessary, that it wouldn't solve the problem.
And if you,
Sorry, Bob, did you have any more questions?
No, that was it.
Jack, do you have any questions?
Well, just, I know this may be oversimplifying it, but conceptually speaking, if the foundry did provide what the building inspector asked them and no more, then how did the foundry violate the special permit?
I don't think that was the
I mean, isn't this, we can tell the building inspector to do or not to do what we think is appropriate to carry out the enforcement of the special permit. But again, what did they do wrong? Other than noise levels being too high, which is what we're discussing, isn't your focus on the fact that the entire, what was requested was not provided, and therefore it denied you the ability to ascertain and to perhaps confirm what you heard, what Truck heard with her own ears, that it sounded loud that night?
That's our major focus. As you said, I'll get to your other question in a minute. We, of course, haven't run these numbers by our sound guy, and I'm not sure that we're going to. It's possible, it's quite possible, that if we had seen these numbers at the beginning, we would not have filed this appeal. We would not have filed an appeal on the sound. And in fact, there are other times that we've requested data and not filed an appeal. The thrust of our appeal was to get the thing done right. Now, we could make an argument that whatever Brian asks for, and he has an obligation to produce the whole thing.
Yeah, but
I'm not going to push
the
that.
building inspector telling her what to do.
Well, I have to disagree with you, not so much strongly on this point. On the microphone, I strongly disagree. It does not take the building inspector to read the conditions of the special permit, which allow but one location for the microphone. Whatever the building inspector says, the permit holder knows how to read the special permit and should be putting it there. And I would make note of the fact that under the laws of Massachusetts, in many other contexts, somebody could spend a lot of money on a house. And
Yeah,
based on a building inspector's mistake.
you do it at your peril.
At your peril. You rely on, if the building inspector says, build it here, and you know you're 10 feet too close to the line, it's your problem, not the building inspector's problem. So that's a situation we're dealing with, but I mean, I don't want to strain.
Do you want time to analyze the data?
But we don't really need any time to analyze the data.
Let's not drag it
Our
out.
thrust here, excuse me?
I said, let's not drag it out any longer.
Mr. Chairman, was I talking here?
No, you asked him just,
I didn't ask him anything.
You said, excuse me, I'm just telling you what I said.
I thought you asked him what he said.
Well, we're a little under stress. It's okay. We're all doing the best that we can.
Okay, all right.
Yes, we
Let's let him
understand.
talk.
Always in my house.
Go ahead and finish up.
I don't think we need more time to measure. I don't think we're going to push the sound level on this one. I think, assuming that there's an enforceable order of some kind to the building inspector that he'll abide by, that we have to have all the data when we make a complaint. That's what we want. That's what we need to have.
Thank you. Okay, Any further questions from the board at this time? All right, how are we doing time-wise? Okay, we've been here an hour, 15 minutes.
Can I make a statement? I'm not gonna yell, but I'm just gonna make a statement in regards to this microphone situation. When we placed the microphone, where we initially did it, I'm Adam Weinberg. I'm Amy's husband and part owner of the foundry. When we placed the microphone, we thought we were doing everybody a favor by putting the microphone directly across from Truck's residence, because that was where it sounded like she was complaining about. Now the microphone is, I guess, where it's supposed to be based on the permit, which is directly across from the deck between the residence and the restaurant. So just understand that we weren't trying to, avoid something. We were actually trying to do something correctly by putting the microphone directly across from Truck's house, her private residence. Now let me just say that this whole thing is an exercise in splitting hairs. I know that it's the planning board, the planning board's problem about basing this permit on something. It should have been on the hours, not on the decibels. We go to 9:30, on a rare occasion, 10 o'clock, right? It would really benefit all of us if you, as Gunnar did, made a site visit, came to a show, understood what we are doing. The constant argument from this side is we have a right to have this law backing us up. Well, where is the right for us to not be harassed? We have been at this clown show for 3 years, so excuse me if I sound impatient, but 3 years, and it's no secret that there has been a propaganda campaign on Truck's behalf against us from the get-go. The minute we were in the middle of COVID, we were outside.
Can we keep on topic?
We were out, okay, so now they gave us a permit for 1 year, and then we got back to the permit, back to the planning board, and got another permit for perpetuity with this microphone. We thought we were over it. The detriment is no longer on Truck's behalf, the detriment is on our behalf, because if you add up all the time and effort and money that we are putting up with, it's a hell of a lot more than the 2 minutes here and the 30 seconds there and the 75 seconds here, there, and everywhere, and we can just keep talking about this till we're blue in the face. And it just becomes ridiculous. So I agree, we do need to go back to the planning board and solve this, because we don't have a rock club, we don't have a biker bar, we don't have a strip joint. This is, some common sense and some discretion needs to happen at a certain point. And if you want to fine us, fine us. But to me, it seems like our neighbor is throwing darts until she hits 3 bullseyes so that we can get our permit pulled. That seems to be my perspective. It's pure harassment. It needs to stop.
Okay. I'm going to open this up to other public comment. But I'm going to
Keep on focus.
But I understand that emotions are running high here, but if there's, what we're talking about are the circumstances which involve the particulars of how the sound was measured and how the building inspector response. So if anybody in the audience wishes to speak, come on up at this point. Otherwise, I'm going to close comment from the public. Okay. Now we're going to have an opportunity to hear from each of the participants up here about how we want to address the issues that have been brought up. And
Touch, if you're closing the public hearing,
yeah,
you should say so.
I just did.
Okay.
I asked if anybody was coming forward, and so we're closing it. Unless we have a particular question we want to ask someone from the board. So, Jim, I'm going to start with you. Where are you feeling about the decision tonight? And also, I particularly take to heart the suggestions that have come from both sides on what we need to put in our findings and our recommendations. And I'd like to hear your thoughts on
Detail that the best I can. My first comment is I'm a little kind of annoyed that we're still talking about the location of the microphone after, that was a kind of a, like I would say, Gunnar brought that up at the last appeal meeting, and, that kind of blew up. That was, I think, caught a lot of people off guard. So all I'm gonna say is I really hope that's where it's supposed to be now.
Yes.
And if that needs to be confirmed by Brian again and put in writing, let's make sure that that's satisfying the special permit. I think about with Brian and requesting the logs, I think when Brian's asked to request the logs, Brian should request the whole entire performance. Under all the circumstances of what's going on, just request the whole thing. Who analyzes that? I think right now it's Brian. I don't think that should be put on truck. Obviously they can look at the data, but the way the permit is now, I think that's up to Brian to review and enforce if need be. If he needs to learn how to do that, then we need to figure out how he does that, and so that can help him speed up the process. If that's a problem, and a continued problem, then the town either needs to hire someone, but I think that's gonna come down to the, when the special permit is looked at again. So that's where I'm at. I don't know if I answered your question, Mark.
Thank you. You've started us out. Robin?
I think I would pretty much agree on both of those points. And in terms of the location of the microphone, I think it would be probably beneficial if the board does request it be provided by Brian in writing or a drawing of the exact location, just so we have that documented. And I think based on everything we've heard here and basically based on condition 6H, I think anytime there is an alleged violation, the zoning enforcement officer should request the data from the full night. That should be provided to truck or whoever complains, and that it is on the zoning enforcement officer to analyze that data. So pretty much repeated what you said. Beside that, I do think we might end up back here again, just because I'm not so sure the data is good data quite yet. It's not, I don't mean to say anything wrong with the microphone or where it's placed, but just as the permit is written, even you're seeing like 145 seconds over, so that technically is violating the special permit as it's written, right? It's over 2 minutes, just over the 65 decibels. But then you have to go the extra step to listen to it.
What the true origin is.
Yeah, with what the true origin is, and then it I don't think in this case it doesn't sound like it was the music. But I think it's a bit of a clunky process. I think oftentimes when the data is requested, it probably will show being over the limits. So I'm not sure what we do with that at this point, but and I don't know what the zoning board necessarily has authority in terms of over how a special permit is written. I'm not really sure, but I think that language would benefit to be modified. I mean, I especially like listened to certain points in the reports we were given, you know, from Herb. At one point he said it's entirely possible that the bass might be unbearable inside the restaurant while not exceeding the limits. It's just, I think relying solely on this data, the decibels, is potentially not, I don't know, not the solution moving forward, but not to say, you know, anything has been violated from what I can tell.
Thank you, Rob. Good, I'm gonna ask you to go next.
Well, you know what I had to say about the findings of this particular incident, so that's, I won't go through that again. I agree with the others that Brian should be provided, or should ask for all of the data, and that it should be provided in a format that's usable. And I think it will be. I think that PDF incident was apparently a one-off. So that's that. At the risk of belaboring the microphone issue, I was on the planning board at the time this was done, and I'll have other thoughts about that. But the microphone, the placement of the microphone came from consultations with the sound engineer that was found by Dana Bixby, the chairman of the planning board, and discussions with that engineer about the environment and what would be the best place to place the microphone in order to pick up the sound that would be coming from the room where the sound originates and the way that the room resonates. And there were recommendations that came from consultations with a professional sound engineer that Dana had prior experience with on other tasks. So that's where it came from. And I understand maybe the best of your intentions to put it closer to Chuck's house, that would be good, but actually by moving it away from the source of the sound, it may cause it to say hear or recognize less of the sound than it would have. And the special permit was kind of constructed around the way that these kinds of things were done in other cities, and the language tends to be, you know, sound measured at the property line, you know, at certain levels, and placements of the microphones and so forth. So that's where that came from. And so it makes sense to put it back where it was originally spec'd, just for no other reason than it puts it where it was expected to be in relation to the source of the sound. You're probably not seeing any difference in the ambient, because the ambient sound level is pretty much the same in that whole cavity around there. But it would be interesting to do a test of producing sound inside the venue and move the microphone and see what happens. So, I can't resist the urge to do this. When we were trying to get this permit done, this is the way it happened was not the way I wanted it to happen. You folks may recall that at that hearing, I suggested that we not issue the permit without going and doing a site visit. And you can play back the recordings of the meetings, you can look at the quotes in the newspaper of what I said. Someone needs to go there and generate sound and listen to it in the environment and decide what's appropriate and what works. These things that were created in the special permit were done with the best of knowledge in looking at how these kinds of permits are generally spec'd in other communities. And but you have to recognize that every environment's a little bit different, and it's complicated down there. There's a lot of reflective surfaces for sound, and it needed to be done. That was, my suggestion of doing that was flatly rejected. I understand you were under time pressure to get things done, but you were absolutely, I'm speaking to Amy and her attorney, you were absolutely unwilling to consider doing that at the time. And I know why, but those are the facts. It's in the record, it's in the audio if you want to go back and review it, but this, you know, if I can send a message to the planning board or whoever is going to rework this, it needs to be done right. I mean, you said no good deed goes unpunished. I have another one back, another little quip. You know, there's never time to do it right. There's always time to do it over. It should have been done right the first time, and it wasn't. It was done, you know, just to the best of the planning board's ability in a little bit of a vacuum without actually studying the real environment and listening to the sounds. Sorry, in the sermon.
Thank you. I'm going to go next, and then I'm going to let Jack wax poetic.
Thanks a lot.
I'm in agreement with what's been stated by my fellow board members. This has shown that the best intentions of a special permit were inadequate in dealing with the issues as they have arisen of having a live performance venue in town. And I like the suggestions that have been bandied around. I think serious. I think we, in our findings, we're going to list some of those suggestions. I'm hoping that we will be able to come to a vote and then talk about what kinds of findings we want to make sure that we include in our final report. So with that, I'll pass it to Jack.
I don't have too much to say that's different than what the other board members were, except perhaps maybe to make it a little bit more particular. For example, on the microphone issue that we place in our findings and our order to the ZEO that he pay particular attention to what the special permit calls for its placement, and that he periodically check it. And I have in my mind here, seems like every 30 days would not be too onerous on the building inspector to do so, because we just can't go through this again with the, go ahead.
I just want to mention, I think the microphone is only placed when you're having an event.
That's correct, because the microphone is, sorry, may I answer?
Yeah.
Yes.
The reason the mic, I know that my partner said that the microphone, we placed it in a place where we thought that it was going to work better in terms of the residents, but the microphone was designated to be placed smack dab in the middle of our designated handicap parking spot by the planning board. There's a handicap ramp that comes down, and the spot necessarily was right at the bottom of the ramp. And that is exactly, because we measured the 18 feet from the west side of the building, that's exactly where our handicap ramp is.
That's at the property line?
Correct. That's a parking lot right there.
Yeah.
So we put it at the property line, and it's gonna get run over by somebody trying to park at our handicap ramp. So what we've decided to do is, because we also have a retail store in our property renting from us, so we can't really block off, I can't put a permanent post there. So that's why it's temporary every time. So we put it there for events, and we put cones so no one runs over our $5,000 worth of equipment. But it is measured exactly where it is. And for a while, we notified the planning board that we had marked it off with or an orange X so someone could come down and look at it. And Brian approved it to us. He may not have written something to you, but he looked at it and said, yes, this is where it's supposed to be. We measured it out to the property line and from the west side of the building, 18 feet. So that is the initial reason why it wasn't where it was absolutely designated, because I don't think the planning board took into consideration also what was happening at our property line, right, you know, where that mark was. So now we moved, Brian said it was okay that we moved the handicap parking space over so that there's still a handicap parking space, but it doesn't coincide with where the bottom of our ramp is. So we were sort of caught between, it was like a little bit of a catch-22, but we wanted to comply with this because we're losing so much money on this issue that we decided to just make it a temporary for every event, so we don't leave the microphone out there. Plus, we never leave the microphone out there because it's gonna get trashed. But, so we put out a stand and just put cones around it in the hopes that no one runs it over.
So my point is just a random 30-day inspection.
Well, I think maybe we can tailor it to, or amend it so that it's it's maybe perhaps once a month during an event.
Right,
Yeah.
exactly.
So that would be my vote, once a month during an event. And again, I don't want to beat this to death, but, I mean, the language says facing the Foundry building and approximately 16 feet from the west end of the Foundry building.
Yeah, that's where it is.
Nothing more.
Well, but it's also, the sound has to be measured, if you look at the other parts of the special permit, from the property line.
Yeah.
So it has to go where our parking lot ends is where Harris Street begins. So the microphone has to be there. So it's 16 feet from the west side, but it's at the property line. It's
Yeah,
not right
yeah.
up against the building. That,
Okay.
so that's why it's where it is currently. And it's been there for all of the events since you instructed the zoning enforcement officer to tell us the minute that he told us we moved it.
Okay. So.
So we have evidence of the sound from that microphone during events from weeks now.
All right.
Yeah.
My vote is just to have the CEO monitor it periodically. And a suggestion is monthly during an event, and that we make it part of our findings. And that the CEO provide the entire data, not in a PDF form, to any, or in connection with any complaint, keeping in mind that I'm just making an observation, Truck, that if there's going to be complaints, my natural thought would be coming from you in terms of where your location, but it doesn't necessarily, it's not restricted to you, it can be anybody, right? So, and that the building inspector the zoning enforcement officer be instructed to, and I don't know whether or not we can, that's why I was looking for some specific language about telling him what we think he should do. That would be understandable in terms of doing, converting it to a spreadsheet. But I look to you for some language for that.
In the findings.
In the findings, that we make a finding and that we instruct the building inspector to do so. And that if he's not capable of doing it, we can, that the town representative or the board representative talk to him, discuss it with him, ask him if he would be, whether or not he could be trained to do it. But if he can't be trained to do it, then as I mentioned earlier in the meetings, you know, we're going to have to find, and when I say we, not necessarily this board, but we could put in our findings that it's a necessity. The town needs to do something like this in order to enforce the special permit that's in its form, or it's got to be altered by the planning board in some other manner that makes it enforceable. That right now, as the enforcement agency, we're finding it to be unworkable. I still don't quite understand, or I guess maybe I'm saying I'm disappointed in some respects that that the special permit was not renewable. I just don't get that. It would seem to me that the special permit of this nature and of this specificity for what it was seeking to remedy would have some sort of a review period, especially if people didn't go out there for whatever reason and experience the real life, performances rather than sitting back and listening to an expert, which I think is helpful, but then writing it up that way. But it's unfortunate that it's not reviewable, and it takes some act by either an interested party or the holder of the special permit to seek a modification of it. It's just unworkable. We're finding it to be unworkable. And we're trying, at least I am, it's frustrating because there's nothing, I don't feel like we can do anything to stop it, to stop this. It's going to be a repetitive process, and many of the same concerns that we have now, we had in the last appeal hearing. It's going to continue. And as both parties have pointed out, and the parties themselves, people are spending money here, and we're aware of it. And these things are not cheap. I'm, for one, I'm very empathetic towards both parties for what they're having to go through here. So if Brian can't do it or won't do it or doesn't want to do it, then I think the town has to find some supporting cast to help him do it, so that it's in a format that everyone can understand and that we can decipher, and people like us and like me in particular can really look at something that I can see and opine that it represents a violation or it's not a violation, but it's not there yet. So for purposes of this appeal, I feel that to the extent that we're telling the ZEO to do that, we're sustaining the appeal. And beyond that, I'm not sure, and in addition to what I've said, I'm not sure what else we can do or what we should do. If anyone else has any suggestions about any language that we can employ to give the building inspector direction, then I'm all ears.
Well, I think we can go through the tape.
Yeah, right, right.
Because we've heard.
One more, just one other comment about Bill's suggestion. You know, I, for one, the way it's written now, and the fact that the holder is the foundry, I don't know if it's really fair to, and I understand why you're saying, why your suggestion is, and I'm all ears to at least a portion of it. But when you got into the shifting the burden.
Not shifting the burden. I understand your building inspector does not have the computer skills. If you can train him, then it's that easy, great.
That takes care of it, right?
It takes care of it. But my sense from his frustration was he didn't have, and maybe didn't think he could acquire, the computer skills, and I don't know where it goes.
We may have to bring
Right.
somebody else,
So-
the town may have to bring somebody else in.
I personally don't think sorting an Excel spreadsheet isn't an insurmountable task. It really shouldn't be. I would add one more point, which is, I think that this board should be more proactive in encouraging town council in the litigation to be more engaged in the appeals, the land court appeals, to drive this thing to a mediation, and have the town, most of the time in a zoning appeal, the town stands on the sideline and doesn't have a dog in the fight. This town has a dog in this fight because of what's going on, okay? And your town council, through the way town councils typically work in a zoning appeal, are standing on the sideline watching the principal players duke it out. This case is begging for a mediation with a qualified mediator, perhaps doing the kind of site visit you're talking about, taking some time to get it right, and actually doing this in a more constructive way, and getting real input from the town, who is in fact the defendant in this case. The town is a participant in this case. The planning board,
How's the town a party in this case?
because it's a defendant in the zoning appeal.
Because
The planning
in
board,
zoning,
you mean?
The
yeah,
planning board's the
planning.
defendant in the zoning appeal. And the typical role of town council in a zoning appeal is to just completely be passive and do nothing, and just whatever the chips fall, where the chips fall. I believe this case is different. I think the town council should be encouraged, and maybe your findings can help do that, recognizing that this special permit needs to be fixed, and in going through the entire trial process and coming back to the planning board with, a hodgepodge is not the best way to fix it. The best way to fix it is to be proactive in a meaningful mediation where the town has a seat at that table too and says, hey, wait a minute. In fact, you have an interest, but we have a town have a slightly different interest, right? And if you put those three parties in a mediation, you might actually get somewhere, because I can tell you right now, we're not getting anywhere.
Has the town done anything than a sort of a carte blanche denial of the complaint?
No, the town has been cooperative in some minor ways, but they took their usual position when the discussion of a discussion of mediation was held early. The town usually, in all the cases I've been involved in, the KP law is involved in, they declined to be involved in mediation. And I would also point out this, we're talking the town as if the town is a unitary entity, but it's not. Whether it should be, it's not. We've got the planning board as a party. This board is not a party to that litigation. The select board is not a party to that litigation.
But they could be a party to
Excuse me,
mediation.
excuse
They could
me.
be a party to
Hold it.
mediation.
Go ahead.
It's primarily between the parties. And if, let's say it went back to the planning board one way or the other, and we didn't like what came out of it, we would be right back in land court. We're not bound, we don't give up our right of appeal by going back to the planning board. And that would just prolong the process even further.
One of the options is,
Not if you reach
one of the
the deal.
options is to send it back to the planning board with findings, right?
With instructions,
well,
that's
yeah,
what
with
we've talked
instructions.
about, yeah, but I'm not sure we can agree on. I'm not sure we're anywhere close to what the proper solution to this problem is, and I don't want to get into it here.
Okay.
I'd be happy to, but I don't think it's appropriate.
It's not appropriate now. Thank you.
Well,
You know,
we want to try to resolve things, and we can't get directly involved with the litigation. But, the way my mind works is that if we can somehow work in our findings some language that will head in that direction with what we, on the ground level, have heard and found, and then give some direction or suggestion to town council, then maybe something will happen.
I don't think town council disagrees that the conditions are a problem. And I think town council suggested in a nice way to the planning board before the decision was written that if you base it all on decibels, you're going to have problems. So, whatever you want to do. But I mean, the suggestions that I hear from the permit holder as to how to fix this, you know, like wood by hours. It is so far from any place we are. And you've got your engineer talking about how, you know, dealing with decibel measurements at the property line doesn't relate at all to how they're perceived in the house or in the business, which is a real source of detriment. I'm not sure how far you can go with your findings without going well beyond the scope of what's before you.
I just think the findings should be based on what we have in front of us for the special permit, as it's written, and what we expect of Brian to do moving forward until there's change in that.
Well, that's a rather restrictive approach.
Well,
Yeah, I mean,
The scope of the actual appeal is
Yeah.
fairly narrow.
yeah,
and
yeah.
I
But
don't
we're,
think we
you
should
know,
get too far.
but we're being implored to bring it a step farther for the reasons that have been articulated. Okay.
So are we ready to have a motion about how we're gonna vote on this?
I think so.
Yep. Would someone like to put that into language, please?
I'm tempted to suggest Robin do that.
I would
Without
like,
notes.
well, so not including any of the findings, just kind of the, well, I would make a motion to sustain the appeal that, let's see,
What do you want to see?
just that when an alleged violation is presented to the zoning enforcement officer, he provides, he requests and then provides to the applicant the full set of data for the performance in a text format, and that it is also his responsibility to analyze that data in relation to the conditions in the special permit, and if the decibels exceed what is presented in the special permit, he also then analyzes it based on audio. That would be the motion.
I second the motion.
Discussion? All in favor, indicate by saying aye.
Aye.
Aye. Opposed? Okay.
Is your record clear that that's not a violation by the foundry?
That's not part of I mean, again, I'm only one member, and we didn't discuss that specifically other than talking about it, but it's not part of that vote. It's not part of the vote.
Okay, so it's the zoning enforcement's conduct, not ours.
Okay?
Okay,
Thank
so
you.
we have,
I got it.
just to wrap this up, we have to write up our findings based on what we have recorded here and what we've heard. And that will be included in, along with the findings and the decision that we made. And that will be turned at some point over to the town clerk, in which case there will be a 20-day appeal process.
We have an extended deadline here, don't we?
Yes.
So if I don't know what
I don't,
We picked a day way down in January.
okay,
Your decision.
okay, but we're,
we'll have it done before that.
we go before you go. Again, thank you for keeping emotions, which are gonna come up, because we're all human. But I really appreciate the exchange of ideas and the and the feelings of rights and responsibilities. And I want to thank, in particular, this board for doing our homework and showing up. And thank you.
Thank you.
And I
Thank
will,
you from us as well, to the board and to you.
and so I officially close this hearing. Thank you. Okay.
You need to make a copy of that.
Yes, you know where the button is on the other side. It's on the other side. It's,
Okay.
it's,
You better handle it, Touch, sorry.
it's
Here.
Right on that property line.